This Honorable Court of Appeals of Tennessee is now in session.
All right, and good morning and welcome to the Tennessee Court of Appeals. I want to take just a moment and introduce your panel for today. We have Judge Arnold Golden from Memphis and Judge Karma McGee from Savannah. And Jim, I don't see Karma on the screen.
She is there. Are you in speaker view or are you in gallery view? I'm
in gallery view, I believe. Okay, as long as everybody's on, I just couldn't see her on there. Anyway, counsel, both of you have been here before. You understand the way that we're operating. So each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but you need to request that from the court prior to making your oral argument and after you introduce yourself. If you're the appellee, you don't get any rebuttal time. I want to thank Mr. Hibner and his staff for putting this together and the AOC staff for making this all possible from a technological point of view. Certainly want to say how much we appreciate the attorneys and parties participating in this. This is new, this is different, but it's our best way of making the process continue to work. So, Mr. Hibner, if you'll call the case, we'll hear from the appellant.
Candace Howard versus Breck Beasley.
All right. Let's hear from the appellant then.
May it please the court, my name is Jason Creasy. I represent the appellate, Dr. Breck Beasley. I would reserve 5 minutes for rebuttal.
All right, sir. You may proceed.
Your Honors, this is a matter in which the parties were actually divorced in 2011. There was a marital dissolution agreement and an agreed permanent parenting plan. Altogether, Dr. Beasley agreed to pay Miss Beasley, currently Miss Howard, $1,000 per week. That $1,000 per week included $177 worth of spousal support, as well as child support and a $548 payment as far as equalization of marital property. The $177 worth of spousal support, and I'm rounding that off, that amount specifically said in the marital dissolution agreement, which was approved in the decree, that it was transitional alimony. Now, there was actually a motion filed December 16, 2013 to terminate the transitional alimony after Miss Howard had gotten remarried and was cohabitating with her new husband. For whatever reason, that motion was not heard. Mr. Jenkins represented Dr. Beasley back then. I was hired in 2018. We proceeded because there was actually another petition for contempt against Dr. Beasley, which was heard. We also had a special master to determine how much his total arrears would be based on the $1,000 per week. And that was determined. Chancellor Cole found him, Dr. Beasley, in contempt, ordered him to pay attorney fees, ordered him to pay interest as well, and effectively punished Dr. Beasley for the contempt. The issue that we had was,
Mr. Creasy,
yes,
was there any proof put on at the hearing regarding the timing, as far as the 5 years that transpired, the reason why this motion sat for 5 years?
No, Your Honor, because I didn't know. To be honest with you, I told the court at that point in time, I could not say why it wasn't presented because Mr. Jenkins had filed that and Mr. Jenkins had represented him. And I didn't have anything that I could put into the record as the reason for the delay.
Thank you.
Well, let me ask you a question, Mr. Creasy. Was there any deadline or any termination point on this transitional alimony in the MDA?
Well, the MDA, it specifically referenced a certain period of time that he was to pay. I think that was through like 2022, Your Honor. So there was a limit of how long he would pay the transitional alimony. The issue that we have is the chancellor says, I'm going to terminate spousal support. It's transitional alimony, and I'm terminating it and basically arbitrarily selected a December 31st of 2018 date. The law about this says that a court abuses its discretion if it reaches a decision that's against logic or causes injustice to the party complaining. The issue that we have is transitional alimony statutorily says it is designed not for rehabilitation, but to help a economically disadvantaged spouse adjust to the economic consequences of a divorce. She was no longer adjusting to the economic consequences of divorce. Once she got remarried, the proof shows that her and her husband maintained a six-figure income. He paid half the bills. All of that is in the record. The issue that we have is if we do not allow Dr. Beasley to have it retro back to the date of filing, then she receives a windfall. The law specifically says.
Well, let me ask you a question before you get too far here. Are you saying that because it's been designated as transitional alimony, that has some effect on how long it should go?
Well, Your Honor, kind of what I'm saying is it's designed as transitional alimony. The statute specifically says the reason for transitional alimony is to adjust to the economic consequences of a divorce. It also says that a presumption is raised once a person starts cohabitating and remarries that transitional alimony is no longer needed. So,
right. Let me stop you though. But it also says, isn't transitional alimony intended for a short period of time?
It is, Your Honor.
But your MDA said it would go through, or not your MDA, the MDA we're working from said it would go through some period of time in 2022, something like that, if I understood your answer.
It was about a 10 years worth of transitional spousal support.
Do we even pay any attention to the nomenclature transitional alimony?
I think you have to, Your Honor. That is exactly what the language is. The court adopted that in the decree. Legally, it has been determined that's transitional alimony. And it specifically is for the consequences of the divorce. It acknowledges that. It's to adjust to being a single person. She wasn't a single person. So if you say that she receives this transitional alimony post-marriage, post-cohabitation, post someone else making this money and paying her bills, she receives a financial windfall to Dr. Beasley's detriment. And the presumption is raised once you show that she has someone else living with her. And there was nothing to rebut that. The only thing that we had was that the chancellor says, hey, look, Dr. Beasley hasn't done what he's supposed to do over time. He's had to come in and out of court. I found him in contempt several times. Well, you know what? The chancellor punished him for that. The record shows that the chancellor says, I'm making you pay attorney fees. I'm making you pay interest. And oh, by the way, you've got about 4 hours to get $50,000 to the courthouse or you're going to go to jail today. He's been punished for the contempt. What my position is, the law shows that this transitional spousal support, as it was legally determined, should have been terminated as of the date, back to the date of filing, so she does not receive a financial windfall. He's already been punished. This, in essence, was a second punishment by the chancellor due to a contemptuous issue, which I believe does not fall within, when you look and say, is it adverse to Dr. Beasley? Is it unfair? It's unfair because it makes him pay over $50,000 of spousal support that she receives while still receiving support from her current husband.
Mr. Creasy, you're arguing here that the chancellor abused his discretion, correct?
That is correct.
And now I've read the briefs, but I haven't read the entire record. Did the parties both testify at this hearing?
They did.
So you're saying that the former wife put on no evidence that would allow the chancellor to rule in the way that he did?
She didn't put on any proof that showed that she had that need for that continue. So, Your Honor, it says specifically that a finding that they are receiving support from a third person, it shifts the burden for her to show that she still had that need. She presented no proof that she still had that need.
During any of the applicable time period?
No, Your Honor. We went straight from 2012 all the way through the hearing date. as to what she was making, what her new husband was making, what bills he was paying. It was a six-figure income every year.
Thank you.
And if your honors have no more questions, I will just wait for rebuttal.
All right. We will hear from the appellee.
Good morning, Your Honors.
Good morning.
May it please the court. My name is Dan Brown. I'm representing Ms. Howard, and this is my first time before the Court of Appeals. So it's fascinating to me that it happened to be via the internet. But I would like to point out some differences I have with Mr. Creasy. This is a case about judicial discretion. And at the hearing that's in question, Ms. Howard did testify about costs that she incurred post-divorce directly the result of Dr. Beasley. And she testified about things she paid for the children, monies that she did not receive in form of equity from the house, all due to Dr. Beasley's behaviors during the post-divorce matters. I mean, this was an uncontested divorce that became contested practically upon signing of the final decree. And Ms. Howard has had to go back to court numerous times in order to enforce that original agreement, which, by the way, it was $1,000 a week for 10 years. And it was broken down into those various components. And when the special master looked at monies that were owed, it was not just the transitional alimony, it was also the other components as well. The special master found that $102,000 was owed to Ms. Howard at the time of the filing of the latest contempt petition. And one of the consistencies throughout this entire case is the fact that Chancellor Cole was the one that signed the final decree and was at each of those hearings over the 7 or 8 years intervening. And he was familiar with the parties, he was familiar with the litigation, and he exercised his discretion by finding that she did incur costs during that period of time. There was no reason given for the 5.5-year delay in hearing the motion. And he, in my opinion, my humble opinion, reasonably determined that the transitional alimony should go through December 31st of 2018. There was testimony that he relied upon, plus his own observation. He observed back in 2015, and that's in the record, that Dr. Beasley, I suppose I should quote exactly what the chancellor said, but essentially the chancellor noted that Dr. Beasley had done virtually everything in his power to avoid his obligations under the marital dissolution agreement. So
let me ask you a question, Mr. Brown.
Yes.
Do you agree that this is transitional alimony?
Well, I agree that the term is in the marital dissolution agreement. At the time, again, it being deemed uncontested, all Ms. Howard's expectation was $1,000 a week for 10 years. So that was, and I was the attorney for her then, and then I left the case and came back. That was a last minute addition to the NDA. So that language is in there. Her original expectation was simply $1,000 a week for 10 years.
Well, does it make any difference how you term it or what you call it?
Well, I think it does. I think at the time of the entry, no one was looking down the road, but I think just noting your comment earlier, that's a question of law for this body. Does the fact that it said it goes on for 10 years, in fact, make it transitional? You're in the better position to determine that than I am.
Okay, so you don't have an opinion one way or the other?
Well, I mean, I agree with that logic, but I can't exclude the fact that that word was inserted into the document.
Okay. All right. Well, here's the real question. Do we look at this any differently if we're calling this transitional alimony or some other type of alimony? Is the analysis the same?
Well, the analysis, assuming it's transitional, is when should it end? If it's something other than that, then I think the analysis is first and foremost, can it end? And if so, under what circumstance?
I agree with you, but that's my whole question is you've got the parties called this transitional alimony. Do we look at it to determine if it is actually what it is? And if so, do we have the prerogative to change what the parties have said in their contract that this is, i.e. transitional alimony? Can we call it some other type of alimony? And if we can, is our analysis different?
Well, I think you can certainly look at the language, which is plain, and it is seemingly in conflict where the word transitional is in there, but likewise, it says it will go on for 10 years. It did not say it's not modifiable, but it did have a definite term of 10 years. So certainly I think this court can look beyond the word transitional and determine whether or not it is in fact transitional. Because I don't know that the parties assumed on the date they entered it that she would stay unmarried for 10 years.
Well, let me change gears on you. Did Chancellor Cole explain why he did not, or why he did terminate it at some point in time, but did he explain why he picked that particular date?
I don't recall there being an explanation. I mean, I've read the transcript multiple times. Again, his knowledge of the case was actually better than either the attorney's knowledge of the case, certainly not the litigants themselves, but he had seen all of the activity for a period of 7-8 years up to the time of that hearing.
So is there a particular reason, or can we glean from the record a particular reason why he chose this date and why he didn't terminate earlier?
Well, I feel like I'd be speculating, but I can certainly speculate because
I'm just, anything he said or based on the evidence that was presented?
Well, again, based on the evidence presented, Ms. Howard did testify about costs that she had incurred. And again, Chancellor Cole was more familiar with that than the attorneys were, but she testified about, just as a for instance, when it was time for the home to be sold, Dr. Beasley didn't cooperate fully, and Chancellor Cole was familiar with that, and it cost her money ultimately in the form of equity. You know, little things like he wouldn't put keys in the key box so the house could be shown. I mean, it was a pattern of behavior on the part of Dr. Beasley that I think Chancellor Cole concluded it was appropriate for her to continue receiving transitional alimony for some period of time to cover some of her costs that she incurred over those many years.
Go ahead.
Well, again, Your Honor, this is an abuse of discretion case. I think the case law is, well, first let me back up to a couple of Mr. Creasy's points. She did put on testimony that rebutted the presumption that the transitional alimony should have ended December of 2013. There's no explanation in the record why it took 5.5 years for this to be heard, but the statute does mention, I believe, well, let me see, in citing Hickman, in order to determine whether the presumption is rebutted, court must examine the circumstances of the alimony recipient at the time of the modification hearing. So the actual hearing was August of 2019. It was not anywhere near December of 2013. So based on that language from Hickman, the court was able to look at that intervening period of time and look at the conditions that had occurred during that period of time. Dr. Beasley did make a $25,000 catch-up payment prior to that hearing. So that might have been part of the chancellor's rationale for ending it on December of 2018. But clearly, I think the chancellor was looking at the entire period of time. And that's the essence of my argument, Your Honors. And I'm happy to field any questions or turn over the podium back to Mr. Creasy.
All right. I see no questions. So, Mr. Creasy, you have your rebuttal time.
Your Honor, one of the things I was just going to reference is, if we go back to Kennard versus Kennard, it says that the appellate court can reverse spousal support decisions if it's not supported by the evidence or contrary to public policies reflected in the statute. The public policy reflected in the statute specifically says if transitional alimony, if you get remarried, you cohabitate, there's a presumption that you don't need it anymore. The only thing that she talked about was problems she had with Dr. Beasley not refinancing the house, her attorney fees. Dr. Beasley has been lit up paying attorney fees. It would be an absolute double dip to say, hey, he has to pay all of her attorney fees, but also, by the way, that's a reason for not modifying transitional alimony. And, Your Honor, the chancellor treated it as transitional alimony. Even when he made his modification, he referred to it as transitional alimony. If it were a different kind of alimony, if it was alimony in solito, if it was periodic alimony that said that it was not modifiable, we would have a different situation. We have to rely upon the plain language, number one, of the marital dissolution agreement, number two, of the statute. It would, in fact, give her an absolute windfall to be able to do that. And my argument is that this decision was arbitrarily made. Only thing he said at all in his ruling was he said that Dr. Beasley is using this motion in his defense. I think a better way would have been have a timely hearing or to pay the disputed amount into court and not use this motion. And then he just comes through and then all of a sudden decides that he's going December 31st of 2018. He references at one point in time in the record that nothing happened on this motion until I became involved in 2018. That's the only mention of 2018. So I don't know if I am the legal bearer of when that goes back to as relates to the motion, but there's no basis for it. The fact of the matter is over $50,000 of spousal support would have accrued from the time he filed his motion until the hearing date. And all of those things being said, it's against the terms of the public policy set forth specifically in 36.5.121 to do that. And that is the basis for us saying that Your Honors should give him relief back to the date that the motion was filed, because frankly, she got married in 2012. He didn't file this until the end of 2013. She already got a 1.5 year benefit of spousal support when she was remarried. So can't go back past the date he filed his motion, but we could at least get him to that point. And
all right. I'm sorry. Did you finish your argument?
yes, Your Honor.
Okay. We appreciate both of you participating in this process. We appreciate your arguments. We will attempt to get you an opinion as quickly as possible. Again, I want to thank Mr. Hibner and his staff for putting this together, and the AOC technology staff for making it work. Mr. Hibner, if you will recess court to the call of the docket this afternoon.
This honorable court is now in recess until 1 p.m.
Thank you.